Hello, everyone. Welcome to our show, Health and Ethics with Barrister Sabrina. The show has been sponsored by Premier Bank, and we are into our Season 2, Episode 3. And the topic of discussion today shall be arbitration and mediation during and post-COVID 2019. As you know that this has been an ongoing issue and a burning issue. And today we have got some international guests speaking on the issue. And if I introduce to you with them, who have joined us live today. First, we have Barrister Sattar. He's an advocate from the Supreme Court of Bangladesh. And then we have Suressh. He is the partner in Eversheds, Ellias, Singapore. Thank you so much for joining in our show today, live from
Sabrina, you seem to have disappeared. At least you disappeared from my screen. Ah, you're back. Thank you very much.
You can see me. Yes.
The glitches of online.
Yes, no, I haven't disappeared. I am very much here. So since the topic today is about arbitration and mediation, yes, this online thing goes on. So if I start with Samir, Barrister Samir. So during this time, you know that of the coronavirus, the courts are going virtually, and there has been issues in relation to arbitrations in our country, where we have seen that in order for the execution of the awards, of the arbitral awards, we have to go through the code of civil procedure or through the normal courts of Bangladesh, starting from the district judge, which takes a longer time. So what do you think is the impact of COVID-19 in caseloads of different arbitral institutions? And do you think should an individual start an arbitral proceedings at this point of time during COVID-19?
Well, thank you, Sabrina, for inviting us. Hello, Suresh. I'm sorry that our Canadian panelists could not join due to some technical errors. Generally speaking, I think that the impact is or will be very significant. Certain, in terms of your question, relates to arbitration caseload for institutions. Obviously, certain arbitral institutions will see a sharp rise in their case load. For example, the AAA ICDR has already seen a significant rise in their employment disputes given the current pandemic. In a recent webinar I was hosted by the American Bar Association, I was listening to a representative of the International Institute for Conflict Prevention and Resolution. He was saying that their filings have increased 3 times more than its normal rate. Suresh can add on the Singapore filings as well during the COVID period. But one has to remember that historically, that these institutions have accepted online cases from an early stage. So naturally, the impact of COVID, this pandemic, may not be too much on such institution. But in Bangladesh, if you talk about the impact, I think from a Bangladeshi perspective, I think the filings will not increase significantly. I think we are still adapting to the concept of online dispute resolution. It is still at its very nascent stage, and I think that it will take some time, both culturally and from an infrastructure point of view. It is not a secret that not all arbitral institutions in Bangladesh are well equipped to deal with virtual hearings, cross-examinations, etc. So I think regarding the impact, a lot of lessons will be learned from this pandemic, especially in the arbitration scene. Especially for us, we will definitely try to improve our infrastructure with these arbitral institutions. They may acquire better infrastructure to support online dispute resolution and online hearings. So that is what I think the impact will be. Now, your second question, which relates to whether an individual should commence an arbitral proceedings in this time, it's a very interesting question. I think that there are multiple considerations that need to be taken into account. Given the pandemic, a great uncertainty is looming over the parties. So the parties are always very confused in this current crisis that whether they should be commencing or they should wait for a more favorable time. Generally, with such looming uncertainty, the common sense approach or advice, if you'd like to say, would be to strategically wait for a time when the circumstances are a bit more favorable and the uncertainty is no longer prevalent. However, I say this with a caveat that much will depend on the circumstances of the case, and the primary consideration for the parties should be and will be whether they require any urgent relief. And I underline the words urgent relief because that will be the driving factor as to whether a party would be commencing arbitration. Other considerations which may involve, and it is a very important consideration, is as to whether the arbitration process as a whole may be tainted in any form or way. I can give you an example. For example, if a party, and if I require an urgent relief and my opposite party, respondent in a hypothetical case, they may require some time to put together an acceptable defense to my case. And if the arbitral tribunal allows such urgent relief without considering the opposite party's plea of time, then the whole process may be arguably tainted and challenged once the award is rendered on grounds of lack of due process. So I think the factors are very important. It's going to be on a case-by-case basis. Lastly, on this point, if there is any dispute in relation to, for example, force majeure, if the dispute relates primarily around a force majeure event, which I'm advising recently on to many parties because everyone wants to claim a force majeure surrounding this pandemic, I think personally my advice is that the parties should wait, as the pandemic is constantly evolving, and it's not clear as of today whether the pandemic itself can be the cause of a total frustration of a contract or a force majeure event. The pandemic is developing and changing with time, and I think no one can say with certainty that if such disputes arise revolving around that, whether a party should clearly commence arbitration on this ground. So these are my thoughts on the questions that you've raised.
Thank you. You actually raised more of the issues that I didn't come up with, and put in a lot of light to what the situation is currently at the moment. If I come back to Suresh, who has joined us from Singapore. As I was talking to Suresh before the show, that Singapore has totally enacted a different law altogether in relation to COVID-19 issue. So if you could throw us some light on that law, and especially with respect to alternate dispute resolutions, arbitrations, or mediations as such.
Yes, thank you very much, Sabrina. The government issued or enacted a law called the COVID-19 open brackets temporary measures close brackets Act in April this year to deal with the circumstances caused by the lockdown in Singapore. And essentially it creates a moratorium in respect of certain categories of contracts, in particular contracts financing contracts which have a security element over assets, over property, and construction contracts. And essentially it creates a moratorium so that you can't enforce any actions for defaults in respect of these kind of contracts if the default is due to the COVID-19 situation. The initial enactment is for 6 months dating from March, and it's envisaged it could extend as long as 12 months. So I stress this is just a moratorium, and it's only in respect of contracts that are affected by COVID-19. And if there's a dispute as to whether these moratoriums apply, the the government has also set up a special panel of assessors, which are either professionals, lawyers, accountants, or from the universities, and they have a very quick process to determine whether you fall within the scope of the moratoriums that they've enacted. And you don't have lawyers. Lawyers are not allowed to appear during these hearings. You do an online filing. That filing then is served on the other side, and then the other side does their response, and then the matter is placed before the assessor, who will make a determination as to whether the act can apply to your situation or not, whether you should get a moratorium, whether you should get any of the specific reliefs they have granted under the act. It's envisaged that from start to finish, this will take about 2 weeks, unless there's a hearing, and the hearings will be done via email. That's the default provision. So the assessor will ask each party to give their arguments via email. He will share it with the other side, get a response, and then make a ruling on that. And like I said, 2 weeks, 3 weeks, no lawyers, everything is very fast. So this allows people to get quick resolution in the difficult circumstances they have. So a lot of the cases are relating to, for example, commercial leases for properties where, if you're running a shop in a mall and the mall is closed and you still have to pay rentals, it does lead to issues. And if you can't reach a amicable arrangement with your landlord, then you want to try and apply for relief under this act, and this mechanism will allow you to do it.
Okay, thank you. So that's actually a lot of things into play in a very short time. Probably we'll see some new changes coming up as well. So if I come back,
well, I will say that the government have indicated that they will. I mean, this act only was enacted in April, right? They have said they are willing to look at expanding the scope of the contracts. So, for example, last week they also provided relief for officers, people who are running in commercial places like like my firm, for example. And if your office was forced to close because of the COVID situation, and the lockdown in Singapore was 2 months, there's a possibility of getting relief for up to 2 months from the rental. And the government and the landlord are supposed to share that cost, 1 month coming from each of them. But like I said, there are also certain controls on it. So they've already done one enactment to expand the scope of the contracts that are covered, and they are likely to do other things as well going forward. The government is being very reactive to the situation that's faced by businesses in Singapore.
I guess the whole thing about is COVID-19. We have heard that the virus mutates itself. So I guess we are also mutating ourselves to different things and changing.
I think that is a very profound statement. You are right.
Yes.
In fact, when we
in terms of
sorry, go ahead.
Yes.
Suresh, in terms of new enactment, just adding up on Sabrina's points, are there any recent arbitration-related specific laws that have been enacted further in terms of hearing guidelines or anything like that?
Well, there have been no specific rules or protocols enacted by the government. There's no change in the law. But our arbitration center and our mediation centers have come out with protocols to enable parties to carry on with their matters during this period. So, for example, our arbitration center, the Maxwell Chambers, they have an online dispute resolution mechanism which allows you to do video conferencing and document management online to allow parties to have hearings. And quite a lot of hearings have already been held using these services, as well as other video conferencing facilities like Microsoft Teams or Zoom. And not so much for taking of evidentiary hearings, but for arguments. So since April to June, I myself have had 3 hearings before arbitrators on interlocutory matters, and they've done by different methods. none of them have been done by video conference, but one of them was done by parties mutually exchanging their submissions, and another one was was by asynchronous argument. So we exchanged emails. So I sent an email first, then my opponent responded with his email, and the tribunal made its ruling, having seen the emails. So I won't say business as usual, but people are adapting to the new situation and trying to come up with new ideas so that business can carry on. It may not be as usual, but at least it's carrying on.
Okay, so that's actually a lot of things coming up. So with respect to that, Barrister Samir, if I get back to you again, in what stages of arbitration actually may be affected by COVID-19 pandemic? What do you think? And do you think that should current proceedings be postponed, or should online dispute resolution be adopted as such, which we were discussing previously as well?
I think in terms of stages, obviously hearings are the most obvious stage, because hearings, getting all the lawyers, witnesses, and tribunal in the same room for the purpose of conducting an effective hearing. In terms of process, in terms of adversely affecting the process, I think the whole process will be delayed, starting from commencing the arbitration proceedings until the signing of the award. For example, I'm having difficulty trying to collect certain information to present my case or to develop my case, because the clients are unable to communicate within their team members due to lack of availability. This whole lockdown and non-lockdown, these issues are always coming to play, and some people are away from office, some aren't. So these are even from an initial stage before the arbitration has even commenced, or we've even sent out a letter. Whereas, the lawyers may also say that as a result, we are not able to get concrete instructions from the client, what they want to do, what they don't want to do. So the whole process, I think, will be delayed. And once we even send out a notice, then obviously the response which we're going to get from the respondent or the opposite party will also come in a delayed fashion, because they also need to gather their information from their clients. Obviously, they will pick up the phone and say that, listen, we've got your letter. Now we need to get some instructions from our client. We need to get our facts straight as well. And, all I see is delay. In terms of once the process has already started, I think the delay may be handled a bit better, because then it will be under an administrator, which is the arbitration tribunal itself. But the ultimate balance, I think, needs to be upheld by the ultimate responsibility is with the arbitration tribunal itself, by allowing the parties adequate time to prepare their respective cases so as to be fair. Fairness and is the paramount consideration when dealing with such cases during this period of crisis, whilst also ensuring that there is no significant delay in progressing with the whole arbitration, which may ultimately lead to justice being delayed. Should proceedings be postponed, as you rightly posed? I do not think so. Much will depend upon the facts and circumstances of the case. But if the parties are ready and they have access to modern technology, I think then they can proceed with mutual consent. However, if on the other hand, one of the parties is not comfortable, and then if I was sitting as an arbitrator, I would adjourn it for some time in order to accommodate that party. But eventually, I think that the show must move on as long as it is not tainted by any allegations of lack of due of process. I think all the parties with our challenges must move on forward. Otherwise, we don't know where this pandemic is heading, how long it will stay, or how soon it will go away. But we cannot put our life on a standstill because of this. So I think we should definitely not consider postponing it unless circumstances so demand. I've spoken to my friends and colleagues in London, and they were telling me that their arbitration hearings have been delayed by 6 months to a year, which is significant. But those are primarily in relation to investment treaty arbitrations under ICSID and other ancestral laws, where there are other considerations, because usually the respondent is from is the government of a state. So there the situation is different. But for commercial arbitrations, I think as long as the parties are ready, they have the mindset and access to modern technology to proceed with the arbitration, I think that is very, very crucial. And once the show is on the road, I think the arbitrators will need to take in and take certain decisions to ensure that everyone is treated fairly, everyone has a respectable time frame within which they can present their case without compromising any of the fairness aspect of the whole proceedings.
Thank you so
we
much.
have got our Canadian guest now.
Yes, we were waiting to get connected to one of our other guests who finally got connected. Let me just interrupt and introduce one of our other guests, who is James Macphreson. He has joined from Canada Live today, and he is an international dispute resolution specialist. And thank you so much for joining today.
Thank you.
In our show. So we can you hear me and see us clearly?
Absolutely.
Okay, that's great. Thankfully that you got connected. We were actually running off the show, and we just started discussing of how the arbitrations and mediations in all over the world, especially related to Singapore and Bangladesh, we have been discussing at what stages of arbitrations there has been going, and how is it affecting the economy as such. So if I start with you then again, how do you think the arbitrations and mediations being able to help those impacted by COVID-19, well, either as individuals or as businesses?
Well, thank you, Sabrina.
On your side of the world.
I think it all comes down to access to justice, because essentially what you're going to get with arbitration and mediation is you provide the parties with rapid, remote, relevant, and reliable resolution. It's rapid because they get straight into it instead of waiting for COVID to pass or any of the issues inherent in litigation at a time, place, and process of their choosing. It's remote because the parties can do this from their home or their office and so on. It's relevant because the parties choose the type of process and the person that can meet their specific needs and the underlying substantive or legal issues in dispute. It's reliable because obviously, as I'm sure the other speakers have mentioned today, it renders a full and final enforceable award. And mediation usually results in a party-crafted set of terms to their settlement. And so that agreement is comprehensive and it's contemporaneous. So you have the right people in the room, and you'll almost always find some sort of a progression or even a resolution of that dispute. I think what's interesting for the parties is that they can pretty much dictate all of the terms and conditions. And I think that in terms of these mediations and arbitrations being online, it's quite effective because obviously there are challenges, but there are fewer traveling implications, there are fewer costs associated with moving parties around the globe and so forth. But I would drill down a little further and suggest that what's best about mediation at present, for example, is the programs that have been instituted in places like New York and Saudi Arabia and so on, where, for example, in New York, they established a process that's sort of a catch-all. So they actually, for one fixed fee, you get a financial expert, a legal expert, a professional mediator, and they're all brought together in a concentrated way to move things expeditiously. And that's CPR in New York that does that. The Saudis have a COVID program, which we developed, which is specifically there to provide people with a more affordable rapid response to a mediation. And then, of course, you have to remember that emergency mediation has been incredibly effective for people seeking interim relief during an arbitration. So if for some reason, as the previous speaker I heard moments ago mention that there are delays, there are mechanisms, there are ways in which parties can avail themselves, for example, of an emergency arbitrator, and that emergency arbitrator with one of the arbitral institutions, and there are many across the world, they have experience using these procedures and bringing the parties and the arbitrator together to render some interim relief or an interim measure.
Great. Thank you. That added some value to our discussion. So if I go back to Suresh again, related to Singapore again, SIAC and mediation centers in Singapore having made to handle matters during the lockdown. And there has been some other measures as well to handle the whole scenario. Could you enlighten us upon that?
Well, they both have come out with, like I said, they have come out with protocols to facilitate hearings during the lockdown. And primarily these address the questions of doing things remotely. And so the cases are being administered via email with the Secretariat. And like I said, Maxwell Chambers has the technological facilities. So for those parties in Singapore, they can attend at Maxwell Chambers and use the facilities there, or they can access them via the internet. Maxwell Chambers has their own servers, so these are all accessible. One of the problems about remote video conferencing in particular is you need a lot of bandwidth, and it's not always available everywhere. And at least if you're using Maxwell Chambers, you have a dedicated pipe, so you don't have that problem that you might sometimes get. I mean, even here in my house, I don't. My bandwidth is about 1 gig Mbps, which when I got it was considered, very generous. But if you're doing a remote hearing with say 3 or 4 people joining in, you're going to need about at least 4 Mbps, and it's not always available everywhere in the world. So we have to be conscious of the technical aspects of it. Following on something that Samir also said, he mentioned several times the mutual agreement of parties. I think this is also something that's very critical. It is incumbent on all the parties involved that they be sensible and managing the process that's happening. So it's not just the tribunal, the counsel and the clients must also understand the accommodations have to be made so that things can move on. Ultimately, it doesn't serve any person's interests if they are obstructive and matters are delayed for no reason. And also to follow up on one of James' comments, he's right. Emergency arbitration, emergency procedures, expedited procedures have been very helpful. There was a case, not one of my cases, but it was mentioned in one of the SIC newsletters where they did an emergency arbitration by way of documents only arbitration. So, and the matter was resolved from start to finish in about 21 days. So, and this is only possible because parties agreed. They said, yes, we agree. We only do it by documents. So everybody submitted the documents. Had to be done electronically. The tribunal did not ask for hard copies. And he made his ruling, and the ruling was made and it was submitted to SIAC, and SIAC vetted it and approved it and certified it and issued it. Start to finish 21 days. So great things can be achieved if everybody is willing to work towards it.
True. Actually, since things are different, we have to work differently to get the optimum output in the best possible manner. So in this regard, Barrister Samir, if I come back to you again, so do you think that current proceedings be postponed online, which you said, but will there be an increase or decrease in disputes the post COVID 2019? Do you think there would be an increase, or do you think there would be a decrease as such?
Well, personally, I think there will be a definite increase in disputes. Especially in obvious sectors such as insurance claims, aviation, loan default, employment law issues, business shutdown and restructuring. So there will be, I see a definite increase in disputes. It's just a matter of time. Obviously, if the parties are mature enough to handle it within the way it should be, and they can resolve their conflict without resorting to any court or arbitration. I think with every case, there's always one party who is 100% right, and then there is the other party who thinks he's 150% right. So unless you can manage these conflict and expectations, ultimately the disputes will arise. I can see already there are a lot of landlord and tenant disputes that are being raised here for commercial properties. And on a small scale, I'm getting queries from developers as to what's going to happen to our property. The tenants are not paying up, and they have an agreement in place, a lease agreement, and which has an arbitration clause. So these are small examples. On a bigger scale, you have leases of aircraft taken by different airlines and from aircraft manufacturers and operators. So there will be bigger scale disputes, although surrounding a lease. Loan default is already on the high, especially in countries like Bangladesh. And obviously, the pandemic will definitely give a credible excuse for defaulters not to repay their loan. I'm not saying all of them are willful or habitual defaulters, but some of them, some of the unscrupulous ones, will definitely try to take advantage of this. Employment law issues, although I don't see them to be escalating to disputes, because I think everyone understands the situation, and most of the employers have been quite understanding with respect to their employees so far, what I've seen. And I think that they will somehow or the other resolve that conflict through appropriate compensation or whatever scheme they may implement. However, like I said, the other insurance claims, I think there's going to be significant increase in insurance claims. There's going to be significant refusal by insurance companies to pay up, which will ultimately lead to a lot of disputes. Also, since the courts are operating on a limited capacity, if given a choice, I think parties will generally prefer to go for arbitration. You must remember that we are handling one of the largest economic crises since the Second World War, and it's an unprecedented situation, and I just see disputes in the
ourselves with it as time flies by. Yes.
Yes, absolutely.
Thank you, Barrister Samir. If I just could relate that to James. In fact, I would pose you a bigger question this time in two aspects. The first would be, what do you anticipate will be the response of courts around the world to this surge of mediated settlements and arbitration awards? So this is in relation to award. And on the other hand, what role can governments also play in maximizing the impact of ADR among all of us navigating these uncertain economic times at this moment?
Thank you, Sabrina. I think in terms of the courts, there's no question that pretty much every court on earth is endeavoring to create virtual mechanisms. Many, and I believe this will indeed be the case, as Mr. Sattar has suggested, that courts are going to be looking to other alternatives. Among them, they're already around the world sending certain cases, often they're small claims and such things in places like India and elsewhere, where they're diverted to small claims processes. I think increasingly the courts are going to be encouraging parties, as they're doing, for example, already in Saudi Arabia, to divert the cases to a mediation process and or an arbitration process. And incidentally, one of the ways that courts can help is obviously largely to do with awareness building and assisting in legitimizing some of these alternative processes, be they arbitration or mediation. I think it's going to be imperative that the courts encourage this, because, as Mr. Sattar said, they are going to be overwhelmed with all manner of claims and disputes moving forward. In terms of the governments, I think that the governments can assist in transforming any existing programs that they already have in place with new ADR programs. I would also encourage them to revisit some of their provisions in their civil procedure codes or applicable laws, because most arbitration and or mediation legislation is actually pretty good around the world. So they probably have something, but there are some jurisdictions who could benefit from revisiting it. And it doesn't have to take a lot of time to tweak some legislation, because there is this imperative and everyone is sort of all hands on deck in most jurisdictions. So I think you'd see that judiciaries and ministries of justice and supreme judicial councils around the world jumping onto and addressing any of these things. I also think that they need to consider some of the underlying issues, the governments, because some of them deal with remote populations, illiteracy, or unrepresented parties who simply cannot afford or justify retaining a lawyer. So they're going to have to come up with some strategies to address these, including possibly things like telephone mediation or offering different ways that people can access these things, because there are going to be people with limited means who only have so much in terms of resources. Also, I think that lawyers and other professionals would be willing, as they have been in other countries like Morocco, India, Jordan, and elsewhere, to provide pro bono mediation at no cost for small claims. Now, some will do this because they want to improve their skills. And by the way, they may be willing to do some pro bono arbitration in small and medium-sized claims, because one of the ways to take the burden off a number of the courts is to shift large scale, large volume, but small quantum, small disputes that are going to be coming from all corners. So they're going to have to be very creative, very proactive, and very systematic in addressing these underlying circumstances and the commercial consequences. So I think that if they want to move forward, I think they have to make sure that they are considering mediation and arbitration, and that they're considering ways to expedite the diversion of these cases. And since this has been done in many places, I think it's more a question of refining and improving. They'll also have to invest in the infrastructure that Suressh mentioned about remote hearings and so on. And a lot of this need not be extremely expensive. They may not have the Singapore, trunk line that enables you, the pipe that enables you to have a much more responsive and higher bandwidth facility, but they can use technologies like Zoom and otherwise. I really think that, given the uncertainties that are surrounding these, the COVID-related economic crisis, I think people need to really consider how long they want to wait and how firm they have to be in seeking redress and reconciliation. I think people are going to have to be not only creative, but somewhat accommodating and mindful that if they wait too long, as has traditionally been the case. So in Gulf countries, when resource prices go down, historically large companies will wait a year or two to get paid, because they know that once things rebound, the cash will be there, and they don't want to lose those relationships they've developed over time. But now you might see companies basically being a little more pragmatic and thinking that, no, they do need to get paid, and they need to be more flexible, and they need to consider these alternative mechanisms. And I highly suggest mediation as the first step, and then arbitration when they want something completely determinative. But as Suressh knows, and I know Sattar and you know, with the Singapore Convention coming into force this fall, that's going to be a game changer. But that doesn't come into effect until the fall, and it will take the normal year or two before it sort of works itself through. So I think people have to work with what they've got, work with the realities, and make some very personal and commercial decisions in order to get things going perhaps a little more quickly than otherwise.
Well, thanks a lot, James, for giving us the plug for the Singapore Mediation convention. I think actually it is an important development. There's a model law attached to it, and basically it will allow mediation settlements to be registered as if they are like an arbitration award and become enforceable straight away. So this is one thing that governments can do. If they can enact the convention, the model law in place, it will improve the efficacy of mediated settlements. And it will, I'm very sure it'll make them more popular.
Agreed.
But what do you think? So, in fact, I was going to come to Suresh because of what James has said. But coming to that, he also has said something about pro bono. Do you think this pro bono services in mediation and arbitration would be encouraged in Singapore as well? What do you think?
Okay. Well, I talked about the assessors for the Temporary Measures Act, right? Most of us are doing it pro bono. And there's no fees being charged by the Ministry of Law for administrating this service. So that is satisfying a need. We have to look at each case has its own merits. In Singapore, there's a lot of small community, what they call community mediation, disputes between neighbors, things like that. A lot of that is done pro bono. But I think it's not realistic to expect commercial disputes to be done pro bono. So different horses for different causes. But the SIMC, Singapore International Mediation Center, has actually come out with a new scale course for mediations, pure remote mediations, where they've reduced the fees that you have to pay. And to be honest, if you're serious about mediation and there's a substantial sum in dispute, the cost of mediation is minuscule compared to a full-blown arbitration or a full-blown trial. The paying your legal fees and the time that's invested, the savings are tremendous in a mediation. So I do think that any serious dispute lawyer should always consider the option of mediation at a very early stage in the dispute. I'm not saying that every time before things kick off, you go for mediation. Sometimes you have to look at until the pleadings have closed, or maybe even discovery has been completed before you examine the possibility of mediation. But it should always be in the back of your mind. And if you see that this is an appropriate case, I think you should go for it. In Singapore, if you ask the mediation centers, their success rates, they say there's about 80% success rate, which is very high. I mean, it's bad news for lawyers. You don't get all your fees, but it's very good news for the clients because they have there's a significant savings for them. Personally, I've never achieved 80% at my cases that I've taken to mediation, but more than 50% do get settled in mediation, and you have to be alert to see whether this is a case that is suitable for mediation. If the only difference between the parties is, I think I owe you $1 million and you think I owe you $1.5 million, this is a case that can be settled by mediation. You don't have to have a 5-day hearing in court to resolve the difference. These gaps can be bridged. But of course, there are other cases where there's a lot of personal animosity or issues more than just money, and they sometimes are harder to deal with.
Yes, true. Yes, thank you so much, Suresh. That was we got some more information on that. In fact, we didn't know that there were actually so many pro bono works being done in there with regards to mediation and such. We are almost at the end of our show, so if I would like to go to Barrister Samir, my last question would be to you. Since now the world is the new world and it's a virtual world now, so where we have been doing things. So do you think this online dispute resolution or virtual hearings gain momentum to become the norm, or will it be shunned? What do you think?
Well, I would certainly expect it to become the norm. I have been a supporter of virtual dispute resolution from the very beginning. I think not only during the times of COVID, or the pandemic, but generally as well. I think if we, especially in terms of arbitration, if we can adopt this, then it can actually lead to substantial cost savings, which is very important for all parties. Traveling, hotels, etc. Everything, every penny saved is a penny earned for the parties in crisis, right? So I certainly think it should become the norm. In terms of practically, I've also seen that if hearings are done through technology, using technology, then it also saves a lot of extra time. I remember when I was doing my pupillage with my senior here in Bangladesh, and we had an arbitration in the ICDR in Bangladesh, and there were like sandwiches, and there were like break rooms, and people are getting there, discussing. And I was thinking, as a young lawyer, I think I was hardly 24 years old, and I was thinking that, wow, this is what I want to be. I'm getting paid to come to London, and I'm getting paid to speak to all these people and then do a half-a-day hearing. And actually, it's not bad. But when we are using technology, I think it will save that extra time as well, because as it is, we are always worried that when the technology will run out or something, it will have a glitch in the technology and we won't be able to present our case. So our focus is primarily on the case. And then the arbitrator or the judge, in case of virtual hearings, would always be very focused that, okay, fine, what is the issue? What are we trying to present? So the extra fluff or extra time, I think, can be reduced there by saving costs. So I think it should be the norm, whether it is in COVID or not. Will it be shunned? Obviously, there are certain people who are not used to this. They want physical hearings. They'll argue that we are criminal practitioners. We need to, cross-examine our witnesses, and we need to see the body language. We need eye contact. So there are two sides of the story. But since I don't practice criminal law, for me, online dispute resolution is the way forward.
Oh, thank you. In fact, you remind me of some nostalgic moments when we started doing past arbitrations, when we were young. And in fact, it reminds me of an arbitration where we were representing one of the biggest telecommunication industry in Bangladesh. And there, what we had to do, it was fun going to these arbitrations as young, eating lots of different food and getting to know people. So that was part of the arbitration that we used to see and think that it was fun. But yes, obviously, virtual court has its role to play. But again, we do have an issue that for execution of the awards in our country, it has to go through the district court. I mean, it has to go to the court procedure. So probably we need to have a change in the law, or maybe in the structures, that maybe if that is the final award, in that case, it could be more effective. What do you think, Barrister Sattar, with respect to that?
Well, obviously, with anything that lets us go back to the courts or requires us to go back to the courts, that is something that is not within our realm. Arbitration is within the private realm. So the parties can actually adapt and make rules and ask the arbitrator to accommodate to those rules, because it's based on party autonomy. You see, the parties choose how they want to resolve their disputes. But anything that goes back to the courts, there's no point talking about it, because unless, as you rightly say, the laws are changed or online system is giving recognition, there's nothing that much can be done. So we're back to the position where we have to physically go to enforce any of our arbitral awards. So without any change in law, nothing can be done there. But with the arbitration process and the mediation process, which is within the parties' control, and our act also allows parties to come up with rules which they mutually agree, which the arbitrator will honor. So from that perspective, I think the arbitration process or the mediation process is much within our control.
Exactly. So since in our country we have seen, I'm pretty sure it's all over the world, where virtual courts are in process, they are going to the urgent matters. So the question is whether this execution of arbitral awards would be considered as urgent in considering these applications through the courts. So that's something we'd see in the future. So if I come to James, so what do you think now, the situation being all these, we have gone through this arbitration and mediations, how can they be done, or they can, whether they're increasing or decreasing, but what do you think the lawyers can do from their own perspective, or the companies who are suffering, or those who have contracts in them where the terms are there for arbitrations, what steps they can actually take?
Well, I think that adding to what Samir Sattar said, there's going to have to be a great deal of flexibility. I think that given that resources are going to become increasingly under the spotlight, people are going to be looking at every single way to contain costs, as they've done during other economic crises. But I think now it will be even more heightened and more acute. What that's going to mean is that previously, all of us in arbitration and mediation did certain things remotely. There might be a party who has a travel ban and can't enter Dubai, or can't enter Kuwait, or what have you, or another part of the world, or someone who is unable to travel due to health restrictions. So you've often had things like depositions or certain aspects of the process that have been remote and virtual. I think what's going to happen is, because the security has been improved, because the dexterity and competence of the parties has been improved, and because the institutions are doing a better job of providing things like moderators for the technology, I think the lawyers are going to have to recalibrate, and adjust. I think they're going to have to, one of the challenges is this: hearings now and things virtual are limited in terms of time. People have what they call Zoom fatigue and so on. So it means that people can't go beyond about 3 hours, and then they need a break. If lawyers use this, it's really about finding a way to make it work. So I think if parties use this time, whether they're arbitrating, mediating, or even litigating, if they can find a way to adjust the way they operate and the way they interact with their clients, as they did before. They adjusted when arbitration came on, they adjusted when mediation came on. Now I think they have to adjust to the virtual elements of these things. Even when we get back to normal in 1 year or 2 years or whatever it is, I think there's still going to be what Sattar said, this desire to continue using what has worked and what people find satisfactory. I do think, though, that I've always believed it's better to have initial interface face-to-face, and then supplement it with subsequent virtual engagement. Well, we can't do that now, but I think that's what's going to come. I think you'll find that people use, because they want to eyeball a particular expert or engage in a particular part of the arbitration or mediation face-to-face, they will use that. So I think you'll still see, as soon as it's practical, people coming face-to-face. But I think what's dramatically different is that this is so much more cost-effective, that if there's going to be more cases using ADR and less large cases and larger volumes. So people are going to have to consider how they deal with these. And I think a big part of it for lawyers is to educate their clients and to manage their expectations, because that's one of the big, and coach them. So if you're an effective counsel, you prepare the client, but you coach them, you manage their expectations, and you get their commitment to persevere. I also think that there will be, just imagine if you have arbitrations that can only last 3 hours. Interestingly, certain developing parts of the world have had that as the norm. Arbitrations only last in the morning and then they recess and so on. So interestingly, that's what I always find about history. There are times when your disadvantage becomes your advantage. So people who in the past, in places like Sri Lanka, were unhappy about the fact that arbitrations only lasted a couple hours and were usually in the morning or afternoon and that was it. They are adroit at this. So they may actually have an advantage moving forward because they already know how to work within this constraint. So I think it's going to be very interesting. I hope that I know lawyers will adjust, but I think that companies need to start thinking really more broadly about their strategy, about how they manage these cases, because there will be also, they're interlinked. If they have literally with questions of cash flow and securing assets and things, they're going to have to be very strategic as to which matters they bring forth first, because companies only have so much capacity to manage these cases. So there may be a litigation department of a fairly large regional player in Bangladesh who is very comfortable with 20, 30, 40 cases. Well, now they've got 200 cases. How are they going to manage that? And they're going to have to prioritize, and they're going to develop new skills. So I think it's really a question of stepping back, reflecting on the whole of the challenge for your client or your entity, and trying to work through a very strategic approach to using some litigation, some mediation, some arbitration, and prioritizing them. And it's going to be very challenging, but I'm very optimistic, especially with people like the three of you on side.
Well, I will add that I was going to add that the technology rabbit has already come out of the hole and is running. We're not going to be able to put it back in. And for example, in Singapore, even before COVID-19, the courts were doing direction hearings by telephone or by video conference. And for criminal cases, accused persons were attending direction hearings by video link from the prison. They were not being transported from the prison to the courts and then back again, with all the security and logistics issues that's involved. So the one thing that has happened in COVID-19 is video conferencing has become far more commonplace, right? 3 months ago, I had never heard of Zoom. Now I'm Zooming almost every day, right? So, so these, we are always progressing. We are never standing still. And although I often hear counsel saying, I need to look at the witness in the eye, I need to read the body language, there are all these things I can only sense in person, I never hear judges saying that. No judge ever says, well, maybe some judges said it, but I've never heard it. But no judge, in my experience, has ever said, unless I have the witness in front of me and I've got all my senses tuned to him, I can't tell whether he's believable or not. It's hardly ever the case. So counsel, we're always very comfortable with what's worked before, and we're very reluctant to change. But if the judges and the tribunals are moving forward, we have to catch up. It's inevitable.
True. Thank you. Thank you so much, all of you. That was a very fruitful discussion. And we actually have come through a point where we see that actually not only litigation, we need arbitration as well as mediation. Three altogether, probably more into a mutated form, a little bit more in the virtual world, to adjust to the new norm, to the new world, the society that we are living into, and which would help us develop economically and to serve our clients globally and internationally, because people at the beginning where everything stopped and came to a stop still, there was a chaos and there were questions on how to deal with things, how to get into the problems, especially the force majeure clauses popped up really seriously, and all the corporate law firms were really busy dealing with issues with those. But now, since arbitrations and mediations is something that we could focus and lessen the burden on litigations, and that would help us as just to progress and go a little more further in our steps as we go day by day. Thank you, James. Thank you, Samir, and thank you, Suresh, for being live in the show and being so lively in the show and being so interactive, so that our viewers actually got a view of all that we wanted to discuss and much more.
Thank you very much, Sabrina.
Thank you for inviting us.
Thank you, Sabrina.
Thank you, dear viewers. We were live from drtv.net, and hopefully you have learned and understood the discussions that we have today for our future, which holds a lot to do besides litigation, which includes arbitrations and mediations. That's all for now. Thank you.
Thank you.